Hi, and welcome to the Palmer Solicitors webinar. And today we are going to be discussing neonatal pay and leave, as well as parental bereavement leave. There's been new law introduced recently with respect to neonatal pay and leave and parental bereavement leave, and we thought it would be good for you to have a basic of knowledge around that subject. So today you've got me, Ola McGhee, and I'm a solicitor here with Palmer's in the employment team, as well as Samantha Randall, who is an Associate Solicitor in the employment team. And we are respectively based in Thurrock and Basildon. So without any further ado, I will start and discuss neonatal pay and leave. So every year in the UK, tens of hundreds of babies receive neonatal care. This is the type of care that a baby receives in hospital if they are born premature, full-term, with a condition, or if they need medical attention or have a low birth weight. Rather than bringing their child home shortly after birth, the child will be admitted to a specialist neonatal unit to receive the support that ensures that they have the best possible chances of survival and quality of life. The government have proposed to introduce new rights for eligible employees to receive neonatal leave and neonatal pay to support these families when their babies are born prematurely, sick, or need care in a neonatal unit. Currently, parents of a baby or babies in neonatal care rely on their statutory leave entitlements that are existing at the moment to enable them to be off work while their baby's in hospital. This means that parents spend a large proportion of their maternity leave or paternity leave in hospital with their baby. As a result of this, these parents are unable to spend time bonding with their child outside of a medical environment for at least a proportion of the maternity leave or the paternity leave. Where the baby's been in neonatal care for a prolonged period, fathers and partners often rely on their annual leave entitlement or have to take unpaid leave in order to be with the partner and baby after their entitlement to statutory paternity leave and pay has lapsed. This means that, unfortunately, current leave and pay entitlements do not adequately support parents in these circumstances. And so the introduction of this new law will be a positive development for employees and follows the introduction of parental bereavement leave legislation. So, neonatal leave and neonatal pay. The proposal that employees should be entitled to a new neonatal leave and neonatal pay was added to the Good Work Plan to support parents and families. The government accepted these proposals and confirmed that new statutory employment rights will be introduced to parents, and it's expected that they'll come into force in 2023, so next year. We expect the following entitlements to be introduced. However, legislation hasn't been drafted yet, and so it may be subject to change. The first one is parents of babies admitted into hospital as a neonate, which means 28 days old or less, will be eligible for neonatal leave and pay if the admission lasts for a continuous period of 7 days or more. The total amount of statutory neonatal leave and pay available to parents is expected to be capped at a maximum of 12 weeks. Entitlement to leave will be a day one employment right, so it means that once you've started a job, you have that right to take neonatal leave and receive neonatal pay from day one. Entitlement to statutory neonatal pay will be subject to the employee having a certain amount of continuous service and minimum earnings. So that's with neonatal pay, you will be subject to eligibility criteria. How the leave may be taken, that's something, provisions are expected to be made so that neonatal leave will be taken after the employee's maternity leave or paternity leave. Furthermore, it's expected that the leave must be taken in one continuous block, so of 1 week or more weeks, so you wouldn't be able to take just the odd day here and there. Notice requirements will be very short, obviously, because of the circumstances, but yeah, they'll depend on the circumstances. And maximum notice we're expecting to be in the legislation would be for about 1 week. Where employers require evidence, they may be able to ask for a written declaration from the employee. But, you know, as we said, the legislation hasn't been drafted yet, so we're just going on what we think may be the case. In terms of protections, the same employment rights and protections will be afforded to, as with other forms of family leave, namely protection from detriment for having exercised the statutory right to take neonatal leave or receive neonatal pay, protection from discrimination, the right to return to the same job after the leave, or a combined period of neonatal and other forms of statutory family leave if they're absent for 26 weeks or less. So there are definitions associated with neonatal leave. And the definition of a parent is yet to be decided. So consideration can be given to which caregivers should be included. Neonatal care, the definition of neonatal care is also to be decided, and consideration will be given to those babies transferred to relevant palliative and outreach services. So, as I said, watch this space with respect to legislation. What can employees do now? Presently, as you know, there are various family-friendly statutory rights that can be utilised to take time off work to care for a new baby. These include maternity leave, paternity leave, shared parental leave, adoption leave, and parental leave. Employees can also take holiday where agreed, and time off for dependents can potentially be used as well in the very short term to make necessary arrangements of care in unexpected situations. Employers are also free to offer the option of additional paid or unpaid leave as may be appropriate, either in accordance with an established policy or at their discretion. The legal considerations to take into account is that employees aren't yet legally entitled to this specific type of pay and leave. But the proposal demonstrates what is likely to be considered a reasonable minimum amount of time to afford a parent who finds themselves in such a situation. Therefore, it can be used by employers as guidance for what to offer if they wish to provide further support to an employee who finds themselves facing such difficulties before the law is actually enforced. And that concludes my explanation of neonatal pay and leave. I'll now hand you over to Samantha, who will cover parental bereavement leave and pay.
Thank you, Ola. So as Ola said, I am going to be covering off parental bereavement leave and pay, which is a fairly new act that was introduced in the last couple of years. So the Parental Bereavement Pay and Leave Act 2018 has introduced a new day one right to statutory bereavement leave in the event that an employee becomes a bereaved parent. It covers parents who suffer a stillbirth 24 weeks or more into pregnancy, up to children under the age of 18. In terms of eligibility, this right applies to a birth parent, a natural parent. So this is a person who gave birth to a child who has since been adopted, but has a court order to allow them to continue having access to that child. An adoptive parent, if the child was living with them. A person who lived with the child and had responsibility for them for at least 4 weeks before they died. Or the intended parent, and this is due to become a legal parent through surrogacy. It also covers the parent of a child's partner of a child's parent, if they live with the child and the child's parent is in an enduring family relationship. So eligible parents that come under that criteria will have the right to 2 weeks of either statutory parental bereavement leave if they're an employee, and or statutory parental bereavement pay if they're an employee or a worker. So in terms of when leave can be taken, Statutory parental bereavement leave can be taken in the 56 weeks following a child's death. If more than one child dies, the employee is entitled to 2 weeks of statutory parental bereavement leave for each child. So in terms of using bereavement leave combined with maternity, paternity, adoption and shared parental leave, they can be combined for either a child who has died or another child that they have had. So taking into consideration for someone whose child has died, if an employee's child has died, they are entitled to take any statutory maternity, paternity, adoption and shared parental leave for that child. If a miscarriage happens in the first 24 weeks of pregnancy, there is no entitlement to statutory maternity, paternity or parental leave bereavement. However, many people would still consider a miscarriage a bereavement, and an employer should still consider offering time off in these circumstances, which can be both physically and emotionally a difficult time. In relation to another child, so if an employee is due to start a period of maternity, paternity, adoption or shared parental leave for another child, their statutory parental bereavement leave will end when the new period of leave starts. So an employee can take their remaining statutory parental bereavement leave within 8 weeks of their child dying. And an employee needs to give notice as soon as possible. If they take more than 8 weeks since their child died, then they must give at least 1 week's notice. And again, similarly, if neonatal policy is to be introduced, an employee can take any remaining period as long as it's taken in one block within a 56-week period. So coming on to parental bereavement pay, employees and workers are entitled to 2 weeks statutory parental bereavement pay if their child dies under the age of 18 or is stillborn after 24 weeks pregnancy. If they are employed when their child died and they worked for their employer for at least 26 weeks on the Saturday before the child's death, and they must earn at least an average of £123 per week before tax. Employees must ask for statutory parental bereavement pay within 28 days of taking their leave, and that starts on the first day of the week that they are claiming the payment for. Statutory parental bereavement pay is the minimum amount employers must pay staff who are eligible, and that is currently at a rate of whichever is the lower of £156.66 a week, or 90% of their average weekly earnings. But this is obviously always subject to review every April. In terms of any enhanced parental bereavement pay, some employees may offer an enhanced contractual bereavement pay that's more than the statutory amount, but obviously an employee must check their contract if that applies to them. So in relation to the taking of statutory parental bereavement leave, an employee can either choose to take this in 1 or 2 weeks blocks. If the employee takes 2 weeks, this can be in one go or as 2 separate weeks. The leave must end, however, within 56 weeks of that child's death, and the date of the child's death is the first day when that 56-week period commences. The giving of notice to take leave. So an employee must tell their employer or give notice that they intend to use their statutory parental bereavement leave. And in order to give notice, the employee must tell the employer when they intend to start that leave, whether they want to take 1 or 2 weeks leave, and the date that their child died. And this doesn't have to be in writing, this can be orally as well. So when it comes to taking leave in the first 8 weeks since a child's death, the employee can start that leave as soon as they give notice. They must tell their employee, however, before they start their leave. And as we said, this can be the first day of leave, as long as it's due before they are due to start work. They can also cancel leave if they want, as long as they tell their employer before it starts. And this can be cancelled either on the day it's due to start, again, so long as it's before they actually start work. And any cancelled leave can be taken later, provided they give notice again. In regards to taking leave after that first 8-week period, the employee must give at least 1 week's notice. And again, 1 week's notice if they intend to cancel, with again, any cancelled leave being able to take at a later date, provided they give notice again. With regards to claiming for statutory parental bereavement pay, as we mentioned, the employee or worker must ask their employee in writing to receive this payment. They must confirm their name, their entitlement, the start and end dates in which they want to claim pay for, the date of their child's death, and their relationship to that child. Notice of bereavement pay must be within 28 days of starting their leave. And if someone takes 2 weeks off separately, they must give notice for each week that they intend to be paid for. And that can be given for their leave and pay in one document. It doesn't have to be 2 separate requests. And so in terms of what an employee can do to support an employee after the death of a child, if an employee's child has died, it's important that employees do give support to their employees following a death, including when they return to work as well. As an employer, they should take account that everyone experiences grief differently, and each employee's needs will need to be taken into account on an individual basis. That brings us to the end of our webinar in relation to these 2 topics. If you do have any questions, then feel free to get in contact with us. Thank you very much.